This case starts with one of the coldest courtroom openings you'll hear in a sentencing hearing. Before we even know the full story, the judge is already talking about a 25-year prison sentence for aggravated robbery. That instantly tells you this is not some minor theft case. This is a violent felony involving guns, fear, and a convenience store worker who was caught in the middle of it all. Now, here's what makes this hearing especially interesting. The defendant already pleaded guilty. So, this courtroom battle is no longer about did he do it? The real question is whether this young defendant deserves probation and a second chance, or whether the violence caught on surveillance video is simply too serious for the court to overlook. And pay attention to how both sides frame this case. The defense is going to paint a picture of a young man with little support, poor influences, and potential to turn his life around. But the prosecution? They're focused on something completely different: fear, community safety, and the growing problem of armed robberies involving young offenders. What's fascinating is that this judge seems deeply frustrated with what she describes as a changing culture of violence among younger defendants. You can already sense this hearing is heading toward a major collision between rehabilitation and punishment. And once that surveillance footage gets mentioned, everything changes. Because in court, words matter, but video evidence can completely destroy sympathy in seconds. Watch carefully as the defense tries to recover after the court sees exactly what happened inside that store. By the end of this hearing, one decision will determine whether this defendant walks out on probation or disappears into the prison system for decades.
Good morning. Are you Caden Fontanet? And this is 25 DCCR 1759. Mr. Fontanet was previously in court, entered a plea of guilty to the first-degree felony offense of aggravated robbery. It was an unagreed plea. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor. The state has, Judge.
Are there any additions or corrections to the report?
Not from the defense, not from the state, Judge.
And Mr. Coleman, you said you have a witness or some evidence.
Actually, Judge, Mr. Rojas has graciously stipulated to the admission of the surveillance video from the convenience store in question. So
Okay.
I need to call my custodian record. With the court's permission, first of all, I'm offering states one. No, Judge.
Make that states two, because this one was the plea admonishment documentation, please.
I'm offering states two. No objection.
States two is admitted.
Permission to publish.
Yes, sir.
Judge, I think that's all I wish to publish unless the court wants to see the entirety of the video.
I think that's enough. Oh, would you switch that back to the other?
All right, I thought I did. Yeah, back on camera image.
Which you might too.
Oh, you want to?
Try one.
Okay. Well, HDMI one is the laptop.
HDMI two.
This is the exact moment the defense realizes how difficult their argument has become. The attorney openly admits that after seeing the surveillance video, asking for probation is now harder to do.
Okay, thank you.
That's actually a smart and honest legal strategy.
Any other evidence?
Instead of pretending the robbery
or
wasn't
witnesses?
serious,
So
the
just
defense
brief argument,
pivots
if
toward
I
the
may.
Any other
defendant's
evidence or
background and future
witnesses
potential.
for Mr.
Notice what the
Rojas?
lawyer
No,
is
Your Honor.
emphasizing here.
Ms. Rojas, you may
First
make
felony,
argument part.
Thank
Go
you,
ahead.
Judge.
young
Obviously,
age,
after seeing that
unstable
video,
home
it
life,
makes what
trying
we're
to
asking for
earn a
harder to do.
GED, and allegedly making a terrible decision while
What
hanging
we're here
around the
asking for this
wrong
morning,
people.
Judge, is probation.
In sentencing
Uh,
hearings, attorneys often try to humanize
in,
defendants because once guilt is established,
Mr.
character
Fontanet,
becomes
he's
the
a
battlefield.
young offender.
The defense wants the judge to see a misguided young man who still has time to change, not a permanently dangerous criminal. But there's a huge problem for the defense. Aggravated robbery involving firearms instantly raises the emotional stakes. Judges hear excuses every day, but violent video evidence changes the emotional atmosphere of a courtroom very quickly. And when the lawyer says, the court is tired of hearing the same story, That line probably hurt more than it helped. It almost acknowledges that this case fits a pattern the judge has seen too many times before. Here's the big question for viewers. If someone commits a violent robbery at a young age but has little criminal history, should the court prioritize rehabilitation or public safety? Because that tension is about to define the rest of this hearing.
Offender. I know the court is tired of hearing the same story over and over, young guys with guns in here. He's got a limited criminal history. I believe this is his first felony. He's never been on any kind of felony supervision or felony probation. Unfortunately, he's just fallen into the same situation that we see so many other youthful offenders fall into. He's got no direction in life. He's very little support at home. Sees no way out of the situation that he's in, so he goes and decides to rob a store and get some money. Did the wrong thing. And if his story in the PSI is to be believable for what I believe is the right reason, he's trying to help his mom out at home, he's trying to pay some bills, keep the lights on. Certainly, there are better ways to go about doing that. And I hope that the time in jail has taught Mr. Fontanet that. We've got options here, Judge. We can send him to prison or we can put him on probation. Certainly, he's on the road if this conduct continues, he's on the road with prison. I don't know that the day is the best time to make that exit for him. He's got a long life to live. We can send him to prison. He can be there for a few years and come back out. I don't know that he's going to get the help that he really needs in prison. There are programs available on probation that if he's serious about turning his life around, like he says in the PSI, those programs can help him. And if he does take advantage of those, it in turn would make the community a little bit safer, because there'd be one less guy running around with a gun when he does get out of prison, if that were the road that you chose to take. Plan on living at home with his mom. I think he has some younger siblings there. To his benefit, before he was even arrested, he started a GED. I think on the night that this happened, he had just finished a GED class and made a dumb decision to go hang out with these guys that he should not have been hanging out with, and did this robbery. Again, Judge, you've got two options. You can send him to prison, or you can try to get him some help on probation, and hopefully he will take advantage of that. And certainly if he doesn't, we're going to know pretty quick, and you'll have another chance to send him to prison, probably for a longer time.
All right, thank you. What is the status of the other two? Are there co-defendants? Have they been charged?
They have been charged, Judge, and I have both of their cases, Judge.
And they have not been sentenced yet or
No,
anything
Judge.
like that?
No,
Okay.
Judge.
All right, go ahead, Mr. Coleman.
Yeah, I'll be brief. Whether it's the Pine Club Apartments or Rogers Park or a Speedy Mart, you've seen this, and we've seen this in this community all too often. I'm preaching to the choir, Judge. Prayer vigils and advisory committees, all that stuff's fine, but you, Judge, are where the rubber meets the road. You are that person that can protect the community from somebody like this defendant. You are that person that can either let him walk out of this courtroom on probation with a piece of paper with conditions and promises that he won't resort to this kind of violence that you saw on that video, or you can ensure that the community is safe by putting him behind steel bars, concrete wall, and razor wire fence. Judge, I'm just asking, I'm not in the habit of begging, but on behalf of this community, I'm begging that you send this defendant to prison. The message that needs to be sent to this defendant and his circle of friends and anybody who would want to be like this defendant is that if you pick up a gun with the intent to commit violence, you're gonna pick up a 15, 20, 25-year prison sentence, Judge. And I'm just asking that you do this on behalf of people who live at the Pine Club Apartments, who just want to live in peace, people who want to go take a walk at Rogers Park and not be robbed, and somebody that wants to stop at a Speedy Mart convenience store and pick up some snacks without becoming a victim of a robbery. That's all I have, Judge.
Thank you, Mr. Coleman. So, Mr. Fontanet, there was a time some years ago that there really wasn't even a question. Everyone, state's attorneys were recommending youthful offenders, probation. Let's give everybody an opportunity. And things have just changed.
Energy of this courtroom. Instead of focusing only on the defendant, the prosecutor zooms out and frames this robbery as part of a larger community crisis. Listen to the language being used. Apartment complexes, parks, convenience stores, prayer vigils, community fear. This is no longer just about one robbery. The state is arguing that the judge's decision will send a message to everyone watching. And strategically, this is powerful. Prosecutors know sentencing is emotional as much as legal, so rather than debating technical details, he paints vivid images of ordinary people simply trying to live their lives without becoming victims. That piece of paper with conditions and promises lying about probation, that's designed to make probation sound weak and dangerous compared to prison. What's also important is the repeated focus on guns. In many courts, once firearms are involved, sympathy drops dramatically. The prosecutor wants the judge thinking less about the defendant's age and more about deterrence, basically warning others that armed robberies will lead to decades behind bars. But here's where this gets really intense. The judge hasn't spoken much emotionally yet. And when judges stay quiet during arguments like this, it usually means they're processing everything carefully before delivering a serious ruling. The defense asked for mercy. The prosecution demanded protection for the community. And now, the judge is about to reveal which side she believes matters more in this case.
And things have just changed in such an incredibly dangerous way with young people doing what I just saw you do on that screen. I cannot imagine the fear that person had that was working in that store, that he now has just trying to go to work, make a living, and go home. And he has 3 people come in and not just grab a little quick something and run out, but terrorize him for quite some time. Pulling him around, yanking him around, putting guns in his face, all 3 of you. I also, in addition to the PSI, get jail incident reports. And you apparently like to fight and jump people, which is what's been happening in the jail. So it makes it very difficult for me to go, oh, this is somebody that's going to get out and behave, who can follow the rules, because you can't even follow the rules in jail. And the pre-sentence report shows that you're a high risk level, which tells me that after they've looked at everything, that you don't have, unfortunately, a good likelihood of being successful if I were to put you on probation. And Mr. Coleman's right. We're tired of it. And there's got to be something done. So in cause number 25, DCCR 1759, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. And at this time, I'm going to find you guilty of aggravated robbery. I'm going to sentence you to a term of 25 years in the institutional division. I'm going to sentence you to a term of 25 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. This was not an agreement. You have some rights to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You can talk to Mr. Rojas about any questions you have about that. I am making an affirmative finding of a deadly weapon. Mr. Fontenette, I understand that this is harsh, and I know you believe this is harsh, but I think this is necessary. I hope that you go and you make things right. You can get out of prison. You're still going to be young, and you can make your life better. That's going to be up to you, okay? You can go back with the bailiff.
And there it is, 25 years in prison for aggravated robbery. The judge made it crystal clear that the surveillance footage, the violent nature of the robbery, and the defendant's behavior while already in jail destroyed any realistic chance of probation. One of the biggest turning points in this hearing was when the judge referenced jail incident reports showing fights and aggressive behavior. From the court's perspective, that suggested the defendant wasn't showing signs of rehabilitation even after being arrested. What's striking is that the judge still tried to leave the defendant with some hope. Even after handing down a massive sentence, she reminded him that he's still young enough to eventually rebuild his life after prison. That balance between punishment and the possibility of redemption is something you often hear in serious sentencing hearings involving younger offenders. Legally, the deadly weapon finding is also extremely significant because it can impact parole eligibility and future restrictions, including firearm possession rights. And remember, this all stemmed from a guilty plea. The defendant admitted responsibility, but the court ultimately decided accountability required decades behind bars instead of supervision in the community. Now, we want to hear from you. Do you think the judge made the right decision with this 25-year sentence, or should this young offender have received probation and rehabilitation programs instead? Drop your thoughts in the comments below.